Hello, my name is Felina Rivera. I'm an attorney here in the state of Oklahoma, where I own my own law firm. I practice cannabis law and civil litigation. I've been following the cannabis legislation that was presented this session by our Congress. In February, I put out a video that summarized all of the bills that were proposed, and now I'm going to go over all of the bills that actually became law, as well as some of the emergency rules that will be of interest to you cannabis business owners. Up first, we have House Bill 2272. This particular bill was of interest to everyone when it was first introduced because it proposed capping the number of licenses that the state of Oklahoma could issue to cannabis businesses. Even though this bill actually did pass and it became effective as of July 1st, that portion of the bill that would have capped the number of licenses was done away with. So there has been some confusion out there that because this bill passed, now there's a cap, but let me make it very clear, there is not currently a cap on the number of cannabis licenses that can be issued by the state. So without that restriction, there are some other things in House Bill 2272 that you should be aware of. The first one being that you are now going to be required to report foreign financial interest. And in this particular realm, foreign means out of country. There are other times when the use of the word foreign just means out of the state of Oklahoma, but for this particular purpose, for reporting any financial interest that's foreign, it means out of country. And so you are going to have 60 days after you receive your license to report that. There is a form on the OBNDD website that you can go in and fill out right now. And if you have a current cannabis license for your business, you actually need to make sure that you go on that website and report that by August 30th. If you don't do it, you are at risk for immediate revocation of your license. So please be sure to get that done. You are also going to have on-site inspections. On-site inspections will begin being scheduled by OMMA on September 1st of this year. You are going to have two grace periods if you don't pass the first inspection that's scheduled. And those inspections, they're going to be looking for whether or not your business is actively operating or you're in the process of becoming active. They're trying to do away with some of the licensures that are just stagnant. So if OMMA shows up at your business and it's obvious that you are under construction, that you're training staff, that you're building, you're going to be compliant with that. And if they show up for that first 180-day inspection and you say, hey, I still need some time, but we're in the process, there is a one-time mandatory grace period. So they'll give you another 180 days to get compliant, get the ball rolling on your business. They actually do have the authority to grant you a second 180-day grace period as well, but that one is up to OMMA. And so, just be sure if you get your license, be ready for that inspection. They're really just going to be looking for whether or not your business is active or you're on your way to being operational. Up next, we have House Bill 2646. This bill is big. It really is pertaining to the duties and functions of OMMA. It grants OMMA a lot of broad authority to implement some rules that really run the gamut. So I would look for some additional rules to be put out in November or near November whenever this bill actually goes into play. This bill becomes active November 1st. So first we have some changes and really clarification pertaining to patient licenses. Patients have always been able to hold 6 plants and have 6 plants on their property. Now it makes it clear, the new rules and new legislation makes it clear that you can also have the product that is harvested from those 6 plants. I know I've had clients and others in the past go, well, what am I supposed to do with all this pot that I've grown? Well, now it's very clear that you can keep it. There is also going to be a restriction on topicals, so you can only have 72 ounces in your possession. And now patient licenses, if you happen to lose your patient license, you can get a new one printed for $20. There are some changes to business licensure as well. One big change that is of interest to both grows and dispensaries is now you can roll your own pre-rolls. Prior to November 1st, you had to have a processor do that. Now, if you want your pre-rolls to have dipped in tinctures and things of that nature, you'll still have to have a processor do that for you. But now dispensaries and grows can roll their own pre-rolls up to 1 gram as long as they only contain flower. There's been some changes to the application process as well. One great change that I think everybody will be happy about is that certificates of compliance that you have to get whenever you get your initial licensing, if that's from the city or the municipality where your business is located. You probably had to, I'm certain you had to do that whenever you got your first license. And up until now, you've had to do that each time you renewed. Well, that will no longer be the case. A certificate of compliance will not be necessary on renewal after November 1st. So hopefully that will save some of you some money for those that are located in municipality interest in areas that charge you for those. So that is a good change. However, one other change to the application process that should be noted by everyone is that, as you may have experienced, OMMA will often reject the application when you first fill it out because of various things that you missed. And sometimes you resubmit and they reject again, and resubmit and they reject again until you finally get it right. Well, now the legislation has placed a limit on that. You may only get 1 rejection. And if beyond that, your edits that are needed are more than clerical errors, they may just deny it. So you may want to be sure you consult with someone. I'm happy to answer any questions for you on that process as well. My email and my information to contact me will be available at the end of this video and in the information. So just something to be aware of while you're doing your applications and your renewals. There are some changes to transport licenses as well. One good change is that the transport agent license that you can get for your employees, the price of that is going to go down from $100 to $25. And the state has done away with the requirement that agents be a 2-year resident. Now you just have to be a current Oklahoma resident. So that should make it easier for you to hire help to transport your product. That price going down and doing away with the 2-year residency requirement definitely should be good news to everybody. Transport licenses will also now be issued to research licensed businesses, education facilities, and laboratories. So transport licenses, good changes, good news in the changes there. There is going to also be some rules put out soon. I anticipate those will come in the fall pertaining to diversion prevention. The new legislation empowers OMMA and the state health department to expand the rules on diversion prevention. And a lot of that is going to look like requiring written SOP, standard operating procedures, and the number of lights that your facility has and the square footage. This will enable OMMA to be able to see what capacity a grow can grow at. And if you are reporting a small amount of marijuana being grown at your facility that is capable of growing a lot, well, that could raise some red flags in the future. So just be on the lookout for some new rules pertaining to that and diversion prevention. OMMA will also be hiring more people to do sampling. So compliance efforts are definitely increasing at OMMA. And they're really trying to focus on preventing marijuana being diverted out of the state and being sold on the black market. So compliance efforts are definitely on the rise with this new legislation. Continuing with House Bill 2646, there are some new regulations pertaining to laboratories as well. OMMA is now going to be prevented from contracting with any laboratory that is owned by someone who has interest in another cannabis business, which makes sense. They're going to prevent some of those conflicts of interest or potential conflicts of interest there. Laboratory testing, test batches have also changed. Previously, it was 10 pounds, really didn't differentiate between types of product that were going to be tested in those harvest batches or those test batches. But now there is some clearer definition. First off, flower batches, harvest batches, are increased to 15 pounds. Plant materials such as stocks and things of that nature, is going to go to 50 pounds. So anything that's going to be due or sent over for processing, those batch harvests amounts are going to be 50 pounds for testing. Liquid, distillate, and things of that nature, anything in a liquid form, that testing batch amount is now 4 liters. And then any non-liquid product, these are going to be things like edibles and things of that nature. Those are going to be 9 pounds. So changes to test batch limits should be of interest to everyone who's processing and growing for sure. One last thing out of House Bill 2646 is a new law that allows the state health department and the commissioner to label a product that's been found to be unsafe or in violation of the law as embargo. And now the commissioner is going to be empowered to file a case against someone who has an embargoed product that is in violation of the law or found to be unsafe. They can initiate an action against you in state district court. So if you are found in violation of the law and your product is found to be unsafe by the court, then you are going to be responsible for costs pertaining to destroying that product as well as all court costs. So just be sure that you are following all those rules and not putting any product out there that's in violation of the rules. Up next, we have Senate Bill 1033. This bill actually went into effect immediately after it was signed by the governor, so these rules are in place right now. This bill actually first started as just a bill that related to, pertained to clarifying the method of measuring the distance between a dispensary and a school. As I'm sure everybody knows, you cannot have a dispensary within 1,000 feet of a school. However, the way that has been measured has not been made very clear. So this law makes it clear that that measurement is to be from the front door of the school to the nearest door of the dispensary. So be sure that you are within that limit or outside that limit if you are opening up a new dispensary. Of course, dispensaries that are already in business are going to be grandfathered in. However, there is actually a method for municipality, if they want to challenge you and your grandfathered status as a dispensary near a school, there is actually now going to be a process for them to challenge that, but you will have to have more than a 500-foot discrepancy. So it's unlikely that's going to happen to many of you, but just be aware that there is a way for a municipality to challenge you if you are too close to a school. And more details on how that can be done can be found in the summary that I'm happy to email to you. Just reach out and I'll send you a copy. Also in Senate Bill 1033, a limitation has been placed on caregivers. Caregivers can now only serve 5 patients. Previously, there was no limit, and so now caregivers, you can only have 5 patients that you are assisting. Additionally, you cannot charge your patients that you are providing caregiver services for anything beyond the actual costs that you incur to provide them with that service. So that's definitely a new thing that caregivers, just be on the lookout for that. As I said, this particular bill went into effect immediately. If you have more than 5 patients, you need to get that squared away immediately. 2 more things of interest in Senate Bill 1033. First, the cap on the number of waste disposal licenses that can be issued has been done away with. The cost is still a little bit more than your typical business license, being priced at $5,000 rather than $2,500. But now the cap on waste disposal licenses has been removed. However, any new waste disposal licensed business is going to be subject to that same 1,000-foot rule from a school that the other dispensary businesses are subject to as well. And lastly, in Senate Bill 1033 is a new rule on taxing. The Oklahoma Tax Commission may now keep 1.5% of that 7% sales tax on retail sales of medical marijuana. And that tax revenue that they are going to retain is going to embolden the Oklahoma Tax Commission to perform more audits, to make sure medical marijuana companies are paying their fair share of taxes. So just be sure that you are consulting with a CPA, with a bookkeeper who specializes in cannabis law. I'm happy to provide you with some referrals for that as well, and can also help you if you get in trouble with the Oklahoma Tax Commission. And finally, there is a new bill, a new law actually, that is a part of Senate Bill 1033 that is pertaining to publicly traded companies. And this is a pretty interesting one that I'm sure there are going to be companies taking advantage of. So now, publicly traded companies that are formed either in the United States or in Canada, in states where the sale of medical marijuana or marijuana is permissible, is legal, if there is a publicly traded company formed in those states, they may now purchase 40% of the equity of a cannabis business in the state of Oklahoma that has been operating for at least 18 months. Now keep in mind that this 40% equity purchase is in addition to the 25% that out-of-state owners, out-of-state residents can have in the ownership of a cannabis business located in the state of Oklahoma. So there is certainly an expansion. I think this is just foreseeing how the future of the industry is going to go. Of course, you know, I think we're all in hopes of federal legislation that will allow cannabis and medical marijuana to be legal nationwide. And so Oklahoma's legislation is on the cutting edge of that and allowing some equity purchases here in the state. Up next, we have House Bill 2904, which is pertaining to new jobs that the Oklahoma Medical Marijuana Authority and the Oklahoma Health Department are putting out there to help with compliance. And this particular bill will go into effect August 25th. They are hiring a slew of new people. So first, we've got 62 compliance jobs being created. There are also 6 legal and financial positions being formed. 4 investigator positions will be filled, and there are 4 planning and logistics positions that will be filled. Now, all of these positions have to be filled by December 1st. I'm sure it will take some time for them to actually get to work, but they are going to be set up with all of the latest technology, anything that they need to do their jobs. So rest assured, OMMA is upping the game when it comes to compliance. That's really the theme of all of the legislation that has passed this session. One quick bill, House Bill 2930, which goes into effect November 1st, really doesn't pertain to medical marijuana. What it does is actually excludes medical marijuana. There is a way for some people to obtain grant money for acts that pertain to agriculture through the State Department of Agriculture. There was a last-minute line added into this particular bill that prohibits any medical marijuana grow from applying for these grants. So sort of a slap in the face to the industry, but you are not eligible for those Department of Agricultural grants, unfortunately. One other piece of information that has been put out by the rules is pertaining to the seed-to-sale tracking system. I know that this particular item has been of interest. There is obviously some pending litigation pertaining to the implementation of metric. And so because there has not been an outcome on that litigation yet, I don't want to comment on that yet. We don't really know what's going to happen there quite yet. However, the emergency rules that were just put out do actually make some changes that are of note, and I have also summarized the new rules that pertain to the seed-to-sale tracking system in the summary that you can get a copy of if you just send me an email, and I'll send that to you. But one particular thing of interest in that is that the new rules make it clear that the seed-to-sale tracking system that you use, it can be, as long as it is, can be integrated into the state tracking system, which is metric, at least as of now, then you can utilize any system that you want as long as it integrates with theirs. It does still require the use and purchase of those RFID tags, which I know has been part of the complaints in this litigation pertaining to the implementation of metric. But just to be clear, the rules, the new emergency rules do state that you don't have to necessarily use the tracking system, the state tracking system for seed-to-sale purchases and tracking, but as long as your tracking system integrates with it. And so there is a lot of other information that has been put out in those rules that I have not gone over today, but I do have a summary of that. And new rules are going to be put out definitely in the fall pertaining to the November 1 bill and laws that were put into place that become active then. So just be on the lookout for that. And again, reach out to me if you'd like a copy of my summary. Thank you so much for joining me today. I hope that this information has been useful to you. If you have any questions, please be sure to reach out to me. I can be reached at felina@thefelinafirm.com. The information will be provided below. Happy to send you a summary of the information and answer any questions you have. Have a good day and thank you.